Buckle up, guys. Today we are going to watch a courtroom mashup of bluster and procedure. The host teases two chaotic hearings and drops a sponsor. Then the first case explodes. A defendant reads a pseudo-legal affidavit demanding dismissal and invoking Latin-like terms. The judge listens with rising skepticism and signals the bench will reassert control. This clip is a tight hook.
Versus Christopher Cooper, 18 CR 280.
Present, Your Honor.
Okay, you're appearing via Zoom. Were you going to hire an attorney or apply for court appointed?
Your Honor, last week I acknowledged that I would like a court appointed, and I verbalized my email in order to receive some document, neither of which actually transpired. On those grounds and the nature of the case, I would like to move for dismissal of any action or claim against me based on Kansas Statute 60-241.
Hang on. What? On the grounds you didn't get an email?
Failure to prosecute, Kansas Statute 60-241.
Hang on.
I emailed him twice. We watched the video to get the email address. It kept bouncing back. So I sent him one in the mail, like USPS.
Yeah. So we sent it to the one you gave us. We even watched the video because this is recorded, by the way. And I got it exactly right for sure, and it kept bouncing back. So the email's no good.
That's inaccurate. It's a business email.
The email you gave us, whatever, you may have said it wrong because we have
this stenographer, right?
It's recorded. Do you understand?
Right. I do understand. That's exactly what I'm saying. It's recorded.
Good.
Did you write the word dot instead of putting?
The judge methodically dismantles sovereign speak. Jurisdiction follows time, date, and location, and civil claims require preponderance of evidence. He demands a clear plea and identity. Evasive, theatrical answers fail. When the man refuses to be the captioned defendant, the court mutes him, strikes a hearing, and leaves a warrant outstanding. A crisp demonstration of judicial authority.
The period? I mean, what are we saying here?
I didn't send it myself. My assistant sent it. She's very well versed in this. So it's been sent in the mail to your address that you say you are at. So you haven't got it yet either?
No, sir. I would like the court-appointed attorney, please.
You have to fill out the application and turn it in.
All right.
So you don't have it in the mail either?
Not yet, sir.
Okay. Well, I don't know what to tell you. You'll need to come in and fill it out then.
Your state is the one preventing me from getting a license to be able to do that. I don't live there.
You need to figure out how to either
walk,
mail, give us the right address so we can send it to you.
Apartment 110, Ponca City, Oklahoma 74601. Is that what your court clerk has?
That's what she sent it to, sir.
All right. Well, I'll be watching the mail, and if we're going to set this over again, I can't appear at 9 a.m. anymore.
Well, you'll just need to turn yourself in. Actually, this isn't working out. You're
right. If 60-241 doesn't work, let's go with 60-219.
You have to file a motion, sir, and you have to appear.
It's a judicial motion. I'm moving that you file the judicial motion, sir.
Those are also civil statutes, not criminal statutes.
Well, the Supreme Court suggests otherwise, that it can be, let's see here.
We'll go ahead and extend our warrant limits, Judge. We can call this one done this morning.
There we go.
All right. That sounds like a great idea. You're going to have to be here in person. We cannot deal with you remotely. You're not cooperating. All right. This hearing is concluded.
He fails to appear, but it's our fault that he's having criminal legal repercussions of it.
The host jumps in with cutting commentary as the first defendant exits with a warrant still active. He ridicules a refusal to accept a name and notes how simple cooperation avoids escalation. The video then introduces Royal Oak versus Anthony Winston, signaling another sovereign spectacle. This transition is a compact bridge that resets the narrative and builds anticipation for Act 2.
Ronald Polk? Alright, so Mr. Polk, we've got 3 sets of tickets, so we're gonna go through this one by one. All right, so we're gonna start with your newest case, your 2024 case, and it's for no driver's license. How do you plead to those charges?
No contest.
Okay, how did you get here today?
I drove.
Okay, so why do you have a license?
They're suspended.
Okay, so what in your right mind gives you the right to get into a vehicle? When you know you can't.
I had to get to work.
I don't care what you had to do.
I understand.
There's a Via Bus. There's Uber. I don't care if the world's ending. You don't have a right to drive. I do not understand what nobody gets about that. They just think they can do whatever they want because I have to go somewhere. Too bad. If you have to go somewhere, go to DPS.
Magistrate spells out 3 plain plea options and presses for a response. The defendant theatrically refuses. I don't plead to anybody but God, flipping formality into spectacle. The judge's patience thins as courtroom procedure collides with performative rhetoric. This short exchange shows why courts demand succinct legal answers, not philosophical proclamations, and it's ripe for reaction edits.
That's what you need to be going. What is the issue with your driver's license? I'm guessing these other tickets, correct?
I believe so.
Okay, is this your only set of tickets or do you have tickets at any other court?
No, these are the only tickets
These are the only tickets.
that I'm aware of.
So hand over the keys because now we got to treat you like a little kid because you can't do it on your own.
Well, I already texted her and told her.
Well, whoever comes, they can pick up the keys at the front because you ain't getting them back.
All right.
So I just ran your name and when's the last time you had a driver's license?
I'm not too sure.
Like years?
I believe so.
Okay, because I just ran your name.
I mean, when I got put over, he said that I could get my license back. I just need to pay a surcharge or something like that, but I'm not too sure how much all that is.
Okay, have you even picked up the phone that call?
I haven't. Just on the 4th, I got pulled over, and no, I haven't called to see how much everything is.
Okay, and see, that's what gets me, Mr. Ronald, is you have time to do all this other stuff, but you don't have time to pick up the phone and call DPS to figure.
Officer Moran gives the prosecution's call facts, date, time, location, vehicle details, and that the driver ran a red while the officer had a green arrow. Those concrete facts land decisively against evasive rhetoric and force a clash between empirical evidence and ideological deflection. The court presses for date and time testimony. The tension rises as fact punctures fantasy.
You're out because you have to drive. That you don't pick up the phone to see where you're at to get to be able to drive legally. Because you know what the sad part is? You have absolutely nothing holding you back. Nothing. Your name is completely clear.
I mean, I got 9 kids. I mean,
And?
really, I don't have too much.
You had time to make kids, right?
What does that have?
Means you don't have time. You can't pick up 2 minutes to call to DPS. But your excuse is, I have 9 kids, so I should be able to
I
drive.
call DPS and it's too much for me to pay. It's not gonna get paid.
But see, you're already trying to make a problem when you don't even know what you have to pay because by your own words, you have not picked up the phone. You have no idea what your fine amount is, but you're already complaining that you can't do it when you don't even know. That's all I hear is complaints. And you don't even know why you're complaining because you don't even know the amount. Right?
Right?
Okay. So let's start taking responsibility.
I'll
Pick up the phone.
I'm looking at that.
You're going to because now I'm court ordering you to.
Okay.
And now you've got 90 days to figure it out.
Okay. To figure what out? How much they cost, or to get them back?
I don't know. You're gonna have to figure all that out, not me.
All right.
Just like everybody else here, they call DPS and they talk, ask them what they need to do, like adults, and figure it out.
I mean, so if I just don't want to drive no more, I don't have to get my license back, right?
No,
If I
but
don't
that's the
drive.
problem is you're driving. You drove
All right,
over
but
here.
if I don't drive no more, I don't have to get my license back, right?
No,
Okay.
but that's not what I'm asking you. Now I'm court ordering. You're gonna get it.
So you're ordering me to get my license?
Yep. Because you're obviously, I don't trust you that you're not gonna drive. You drove over here.
I just had the young lady before, she handed over her keys, and none of this. All right.
The defendant demands an injured party and misapplies criminal rights language, trying to recast a civil traffic citation as a criminal confrontation. The magistrate patiently explains a preponderance standard and why a sworn officer's testimony suffices in civil infractions. This section is an effective teachable moment where legal clarity dismantles pseudo-legal theatrics for viewers.
You don't trust me not to drive.
And for your information, you don't compare yourself to anybody else because you don't know what her situation is with the girl before you, and you're sitting in front of me with five other violations. She wasn't.
Okay.
Okay, so don't compare yourself to
Okay.
anybody.
Yes, ma'am.
So your next one here is from 2015, and it's for theft.
I don't even know what that one is or from.
Okay. So how do you plead guilty? No contest or
Yes.
not? Huh?
No contest.
All right. So for your theft, I'm going to put you on 60 days probation.
After failing to manufacture an accuser, the defendant's rhetoric collapses and the court moves toward resolution. The magistrate highlights as no rebuttal to the officer's testimony and signals the imminent ruling. This is a tipping point where rhetoric yields to ruling. Editors should emphasize the judge's cadence and the defendant's faltering lines to sell a narrative pivot.
You're going to have a $50 fine plus your court costs, 60 days to pay that, and you're going to have to take a theft class. You do all of that, I will take into consideration your failure to appear. You don't, you walk out of here with convictions for theft. Excuse me? Excuse me?
Nothing.
I didn't think so.
I didn't think it.
You want to say one more word and I'll slap some handcuffs on you because I'm not in the mood for you today. You brought yourself here, and don't get mad because we're telling you the truth. And your third case, no driver's license and fail to turn signal. How do you plead to those charges?
Contest.
All right, same thing. You bring me a license, I'll dismiss that one for $22. All right, turn signal, you're gonna be put on 60 days probation, a $50 fine plus your court costs, 60 days to pay that. No driver's license, you're gonna be reset for 90 days. You take care of both of those, I will dismiss your failure to appear. You do have Omni on all of these that you are gonna have to pay. You've got 60 days to comply with all of that. Besides your driver's license, you have 90 days for that.
The magistrate issues a finding. The defendant is responsible. A $175 final bond option is set, and clear payment and appeal instructions are given. Consequence replaces spectacle as a legal machine finishes its work. The host's follow-up ties up the thread, underscoring the cost of obstinance and how theatrical courtroom posturing typically ends with practical obligations and penalties.
Right? Swing around here to the right.
The final stretch covers more hearings. Judges confiscate keys, scold defendant for driving on suspended licenses, impose probation, fines, and theft classes, and set deadlines to regain licenses. The host stitches outcomes together with sharp asides and a sponsor close. Don't forget to like the video, subscribe to the channel, and we'll see you in the next video.